Jersey LERA. We're very honored today to once again have a member of the National Labor Relations Board with us, Lauren McFerran. Last year, many of you probably were here in person as we put in the advertisements when we were at the Galloping Hill Country Club and we had Chair Ring, and that was an outstanding event. Before that, we've had members, usually recently retired members, but this year we're happy to continue the tradition of having a sitting member here, and we really want to thank Dean Burrell, who's an arbitrator and a mediator and one of the co-organizers, as well as David Leach, who many of you know as the regional director of Region 22 in Newark for the past several years. Many of you already know this. Those of you who don't will be upset to learn that David Leach has retired. He no longer is serving in the capacity of regional director, but he is still serving in the most important capacity, which is a board member of New Jersey LERA. And in addition to that, in his spare time, he's a professor where he teaches labor law. So, I have to say, Dean and David have made this an annual event for the National Labor Relations Board. They like to tell me how mistaken I was by questioning what the interest would be of the New Jersey LERA community in attending these events. And I was very mistaken. Once again, we've got a great group here this year. And, we tend to get people who might not come to some of our other events. So we want to expose you to this. Our next event is going to be in March. If you go to our website, it says that it's about South Jersey. It turns out that I think we're going to, given the gravity of the times that we're living in, instead of having a debate about hoagies versus heroes and things like that, I have a feeling we're going to change the topic into something more substantive. That's something that the board's going to contemplate, and we'll be sending emails about it. So that's something to keep an eye out on. And if you're not on our mailing list, you'll see me, you'll see our vice president, Lucille Alfano, who's going to give an outro once everyone's done talking. If you can email us, you can email the website, you can put something in the chat if you or text in the chat to Dean or to Emily or Emily. We want to thank National. We've got Emily and Bernadette here who are giving us the grace of using their high-tech Zoom chat. And they're not only that, they're also staying here and making sure we don't make any big mistakes. So we're very grateful for our partnership with National as well. So we only have a few more meetings this year. Like I said, March, we're not sure the topic yet, but that will be the meeting where the slate is introduced for elected candidates for New Jersey's chapter for next year. So we do have a lot going on. We're trying to reach out to the entire labor community. We think much like the nation, people are divided also in labor, especially with things going on with COVID and testing and vaccines and everything else. We want to be a place where people could sit down together, break bread, and feel like they're part of one community. And that's why, we think it's helpful to have events like this with member McFerran coming in and basically speaking to everybody and telling you a little bit about, perhaps, I don't want to forecast what she'll talk about, but she might talk a little bit about what happened under the last administration by the NLRB, what things are currently going on with the National Labor Relations Board. Obviously, we're in a period of flux as President-elect Biden will be sworn in a few days. So without further ado, I'm going to turn it over to Dean and David, who are the dynamic duo and do a great job moderating this event. Like I said, I'm going to have to, unfortunately, I've got a meeting, so I'm going to leave, but Lucille Alfano, if you don't know her, she's the vice president. We want you to meet her and hear from her at the end. So thanks so much for listening to my spiel. I see we're now up to about 49 people, so we're getting close to the number of registrants. And I don't know, Professor Dave or Arbitrator Dean, one of you guys want to take it away from me?
Thank you. I will. I had arm wrestled Dean for the honor to introduce board member Lauren McFerran. And I want to thank you, Jonathan, for your wisdom in always having an NLRB program as part of the New Jersey LERA. And I have always, since the day I became director in Newark at Region 22, had a great relationship with LERA because of the support of all of you. And so I thank you all for attending. And I particularly like to thank Dean for his work and helping me prepare this and set this up, but especially Board Member Lauren McFerran from taking time out of her duties. Lauren McFerran has been nominated and sworn, and confirmed by the Senate and sworn in as a board member twice. She was an Obama appointee to the board on December 17th of 2014 and served a 5-year term ending December 16th. She was again nominated by President Trump to fill one of the slots. And as many of you know, the president has the right to appoint a majority to the board, and the minority have a right to ask for a minority. So Lauren McFerran has been confirmed and started serving again in July of 2020, and her term will proceed until December 16th of 2024. There are only 4 board members right now, and she is the only Democratic appointee to the board. So she's had the opportunity to weigh in on a number of issues from a different perspective than we may have heard from Chairman Ring last year. She is a graduate of Rice University. Her law degree is from Yale. She has been a staff counsel at Brethoff Kaiser for several years, and has also been a member of the Senate Committee on Health, Education, Labor, and Pensions. Finally finishing that as Chief Labor Counsel, and has been serving as a board member ever since. We really appreciate you coming and being with us. The New Jersey Bar Member McFerran is a great bar, and they are committed to an excellence in practice. The relationship between union and management attorneys here in the state of New Jersey is exemplary, and the people work really well. So I know you're welcomed by everyone from all sides, and we thank you for your time. I understand, and just so people know, when Member McFerran finishes her comments, we will invite questions. And right before that starts, I'll remind everyone that a sitting board member may not comment on any cases that are before the board or might come before the board. She's obviously can discuss her dissents and positions that she's taken publicly. So I'll ask everyone to remember that as well. So Lauren, thank you very much for coming. We really appreciate it.
Thank you. Thank you, Regional Director Leach, and to Mr. Burrell, formerly of Region 5, I guess, for the invitation to join you all here today. And I just want to take a moment to thank Regional Director Leach for his service to the agency. Our regional offices are the lifeblood of what we do, and it is no easy task to run one of those offices, particularly for as long as you did. And we are deeply grateful for your public service, and I hope that you are moving on to some very, very enjoyable things in your life, including continuing to serve on the board of this fine organization. I'm sorry that I couldn't join you in person here today. My husband grew up in Summit, New Jersey, and so I always welcome the opportunity to revisit the Garden State, if for no other reason than I could finally get some decent pizza and a good bagel. But I'm hoping that at some point that could happen in the future. In the meantime, you'll have to share with me in the chat like your favorite pizza and bagel suggestions or something for the next time I'm up there. I believe the title of this program is the NLRB Update. And as the board is nearing a time of transition, I thought I'd spend some time today doing something of a retrospective, kind of the legacy of the Trump board and where we stand now in labor law. As was mentioned, I am currently the only minority member of the board, so I think it is safe to say it will be a different perspective than Chairman Ring gave you last year. These unprecedented times, I believe, have made the work of the board even more important than ever. While I certainly don't delude myself into thinking that people are waking up every morning saying, gee, I wonder what's happening at the National Labor Relations Board. I do think that job security and workplace safety and many of the challenges that workers are facing across the country right now are one of the issues at the forefront of our country's national attention. And at a time when workers are more vulnerable than ever, the National Labor Relations Act is, or at least should be, the most vital and comprehensive available tool to help restore some measure of economic security and stability for working people. Workers have a right under the Act to come together and advocate for quality jobs, stable employment, and workplace protections, and to address a full spectrum of workplace problems, from unsafe and unhealthy working conditions to unequal pay to discriminatory work environments. Now, that's not to say that the specific laws addressing these issues aren't vitally important, nor is it to discount the importance of conversations about collective action that don't rely explicitly on the Act in its current form. But as a practical matter, in the current legal landscape, the Act is the foundational tool to enable meaningful gains for vulnerable workers. In short, a vital NLRA is essential in these unprecedented economic times. Unfortunately, if I was asked to characterize the overall impact of the Trump board in a nutshell, it would be to say that this board's work has made the Act smaller, both in terms of the scope of its coverage and the scope of the activity that it protects. Now, I want to be very clear here. That's not to say that the current majority will never find a violation of the Act. They find them routinely, just as past boards have. And it's not to say that anyone walked in the door with a nefarious plot to eviscerate the Act and burn the building down. My colleagues on the board are genuinely good people, and I have good relationships with all of them. But I think that the impact of the vision of the Act that the current majority embraces, this smaller Act, whether intentionally or not, will be to limit the utility of the Act as a tool for worker protection and as a mechanism to correct current imbalances in economic power. Now, the most literal way that the Trump board is making the Act smaller is, quite simply, to limit who is protected by the Act. The Act has always, and I would say unfortunately, excluded some categories of workers, often the most vulnerable populations, such as agricultural workers or domestic workers. Today, workers look different in the modern economy than they used to, and the current majority has seized on these economic changes to exclude broad categories of Americans from the Act's protections. The first case that springs to mind in this regard is a 2019 case called Super Shuttle, where the board majority announced a new rule for determining independent contractor status under our law. There's lots of different tests for independent contractor status, as you all know. But under our law, we're supposed to be using the common law test. Under the board's new standard that they announced in Super Shuttle, they've elevated entrepreneurial opportunity above all other factors in evaluating independent contractor status, which is in conflict with the common law test, as I say in the dissent. This is, in my view, clearly contrary to Supreme Court guidance. I mean, the practical result is to permit the use of formalistic trappings, such as labeling workers as franchisees or business owners, to disclaim responsibility for people who do the work of the business. In Super Shuttle, for example, these were workers who did the work of the business in the business's name, working exclusively for them, using only their dispatch system, charging only their rates, subject to an agreement that the worker had no ability to change. These are the facts in Super Shuttle, and that's a near textbook common law definition of an employee. Another large population of workers, larger than some people might think, that have been there's been attempt at least to categorically exclude from the Act is graduate students and student employees. And this has been done not through adjudication, but through rulemaking. The proposed rule would exclude students who work in connection with their studies in any way from coverage under the Act. It would deprive tens of thousands of teaching assistants and other students at private colleges of the right to bargain over benefits and working conditions. Now, I can't talk much about the substance of this because it's an open rulemaking record, but the proposed rule is another example of a very narrow way of thinking about the scope of the Act's protections. A third example is this recent case, Bethany College, involving religious colleges and universities. In this case, the board held that it has no jurisdiction over the faculty at religious institutions of higher education. In so doing, the board overruled a prior jurisdictional standard set forth in a case called Pacific Lutheran University. That test had looked at whether the employees in question actually perform a religious function for the institution. Instead, the board adopted a jurisdictional test from the DC Circuit in a case called Great Falls, where they ruled that the board must decline to exercise jurisdiction over faculty at an institution that, one, holds itself out as providing a religious educational environment, two, is organized as a nonprofit, and three, is in some way affiliated with a religious institution. So that's a very broad categorical exemption for religious colleges and universities. The practical effect of decisions like Super Shuttle and the religious colleges and universities case is obviously to shrink the Act's coverage. That's an obvious way, but there's less obvious and equally important ways to shrink the scope of the Act's coverage as well. And here what I'm talking about is a decision called Velox Express about the misclassification of employees as independent contractors. It's fairly common knowledge that misclassification of workers is a common problem. The Department of Labor has estimated that as many as 30% of firms misclassify their workers as independent contractors not covered by the Act. In Velox, the current board majority found that it was not unlawful for an employer to have misclassified its drivers as independent contractors for purposes of the National Labor Relations Act. According to the majority, telling a worker that they are not an employee but are instead an independent contractor is merely the transmission of a legal opinion and is protected by Section 8C of the Act, which protects the dissemination of views or opinions that do not contain threats or promises. It noted that the majority noted that in order to hold otherwise would, quote, chill the formation of independent contractor relationships, which, while I would say is perhaps an interesting observation, doesn't really relate to the goals of our statute. As I pointed out in my dissent, what the majority failed to consider in Velox is the effect of misclassification on workers' ability to exercise their rights. When an employer incorrectly tells a worker that they are not in fact an employee, it's telling them that they have no labor law rights. So the chilling effect on their ability to exercise such rights is clear. And that's the chilling effect that we're supposed to care about under our law. Allowing employers to mistakenly inform their employees that they are not in fact employees shrinks the law by making it far less likely that these workers will ever attempt to exercise their rights under the Act. As a practical matter, they don't have rights under the law if they don't know that they do. So we've seen a lot of limitations on the who of who the Act covers. But in addition to limiting who the Act applies to, or at least who knows that the Act applies to them, there have also been a significant effort to curtail how workers can organize and protest. So the Act is smaller, not only in regard to who is protected, but also in regard to how meaningful and effective those protections are. We'll start with a series of cases here that limit access to employers' property and channels of communication. Literally, the scope of places, both physical and virtual, that you can engage in protected activity is shrinking. There's a trio of cases that are kind of the lead on the physical access aspect of this question. The first is a case called Kroger Limited Partnership, which curtailed the ability of union organizers to leaflet and solicit on an employer's property when the employer had allowed organizations such as, for example, the Salvation Army or the Girl Scouts to solicit for their organizations on the employer's property. The second case here is a case called Tobin Center for the Performing Arts. There, the current majority ruled that off-duty employees who do not have a right to handbill or engage in other organizing activity in non-work areas of their workplace if the employer is a contractor at the workplace, as opposed to the owner or holder of the property. The third case is a case called UPMC, which changed the rules for access to non-work public spaces. There, the majority held that a hospital could ban a union organizer from simply talking with nurses while sitting and eating in the cafeteria at the hospital, even though there was no solicitation going on, and even though the area of the hospital was open to the public. Under the current majority's line of thinking in these cases, there's a premium placed on employer property rights over Section 7 rights and communications. We've seen new limitations on the access rights, as I've said, of employees and non-employees alike. And there's a couple of kind of principles that emerge from these cases. The new restrictions on activity by non-employees and outside organizers make clear that this board sees union activity as somehow unique or different and inherently more disruptive than essentially identical activity engaged in by entities that are not affiliated with a union. This is manifestly contrary to Supreme Court authority, as I explained in my dissents in both Kroger and UPMC, but it's clearly the current majority's view. The majority has also imposed many new restrictions on what workers, not outside organizers, but workers themselves, can do in their own workplace. Property rights are invoked in these cases, but they're kind of a red herring because employees are unquestionably lawfully present on the property. These are managerial interests at stake, not property interests, which means that according to the Supreme Court, at least, employers shouldn't be able to restrict workers' statutorily protected activity unless it's necessary to maintain production or discipline. So we've seen some real shrinking of the physical space where protected activity can take place. But it's not just access to physical space that has been limited. There's also been limitations on access to means of communication. The first of these is a case that got a lot of attention called Caesars, which overruled the prior board's holding in a case called Purple Communications. In Purple, the board adopted a presumption that employees who already have rightful access to their employees' email system in the course of their work have a right to use the email system to engage in Section 7 communication on non-working time. Now, an employer under Purple could rebut this presumption by demonstrating that special circumstances were present that made it necessary to maintain production or discipline by restricting its employees' rights. The majority's new test says that employees can never use the employer's email system unless there are no alternative means of communication to determine, then that's the test to be used to determine whether you can restrict your organizing activity. This is essentially an impossible standard to satisfy in the modern era, where presumably everyone has some means of communicating other than work email. But more importantly, it's also just a legally incorrect test that's inconsistent with the goals of the Act. As I say in my dissent, an employer doesn't get to pick its preferred channels of communication for workers to use on non-work time, assuming that the restrictions aren't necessary to maintain operations. Indeed, the DC Circuit has explicitly admonished the board about relying on the availability of other channels of communication to restrict workers' protected activity. Moreover, when it comes to balancing the interests between the employer and the workers here, I think the majority just got it wrong. Talking to other workers, communicating with other workers, whether at a physical water cooler or via an email system, is literally the core of what our statute protects. When workers talk to each other on non-work time in a way that doesn't interfere with production or discipline, the employer's interest in limiting that communication is relatively weak, but the employee's interest, the worker's interest in communicating that way under our statute is very strong. I think it's hard to see it any other way, but my colleagues clearly disagree. Another channel of communication that has been limited is the display of union insignia at work. For almost 75 years, the board adhered to the principle, expressly endorsed by the Supreme Court in a case called Republic Aviation, that an employer may not limit or ban employees' display of union insignia at work, absent a showing by the employer again that special circumstances exist. But in a case called Walmart, the majority basically brushed aside Republic Aviation and its progeny and held that employers are now presumptively permitted to restrict the wearing of union insignia, so long as it's not banned altogether, based on any legitimate justification. The justification at issue in Walmart case itself was actually particularly weak, but that didn't seem to be a deterrent. This approach completely turns Republic Aviation on its head and basically thumbs its nose at Supreme Court precedent. The courts have been clear that the employer doesn't get to pick how workers express their pro-union views. An employer's willingness to tolerate some union insignia does not give it a freer hand to restrict other displays that are protected, even if it views those displays less favorably for some reason. Nor does it render an employer's interference with protected rights excusable. Unless there's a strong showing that, for example, there's an actual interference with the operation of the business, or the display of insignia creates a safety issue or something like that, the workers get to pick how they express themselves. So there have clearly been new limits on where and how workers can communicate. The employer's right of control over the workplace has been expanded, and workers' access to channels of communication has been correspondingly narrowed. In the same manner, the nature of the communications that are actually protected by the Act has been limited as well. So we've limited the who, we've limited the how, and now we're limiting the what. And here it's kind of, we start with the definition, I think, of the definition of protected concerted activity, which encompasses two concepts. One, activity that is concerted, and second, activity that is for mutual aid or protection. The Supreme Court has been really clear that both of these concepts should be interpreted very broadly. Concerted basically just means not alone, and it encompasses circumstances where people seek to initiate or induce group action, even when it's not clear that the effort will be successful. And for mutual aid or protection, basically just means related to improving your lot as workers. These are not supposed to be narrow or restrictive definitions. But there was a case that I always think didn't get quite the attention that it should have gotten. I think it came out on a day when all sorts of other things happened or something like that. But it's a case called Allstate Maintenance from 2019, where the board restricted both of these aspects of the definition of protected concerted activity, both the concertedness and the for mutual aid or protection, or at least it signaled a narrow view of what means for mutual aid or protection. First, the majority used this case to articulate new factors that are supposed to be applied in determining what is concerted activity. Now, these new factors have the potential to significantly constrain what is protected by the Act. Asking questions without complaining is potentially no longer protected. Spontaneously protesting a change to terms and conditions of employment upon first hearing about the change, rather than waiting to talk to colleagues about it first, that's potentially no longer protected. The board has historically rejected these kinds of strict criteria to define protected concerted activity, recognizing that it's a concept that needs to be construed broadly to effectuate the purposes of the Act. Now, there's an equally alarming part of the decision here that I think has been really overlooked, and that's the majority's rationale for finding that this particular statements at issue in this case were not for mutual aid or protection. Now, like I said, for mutual aid or protection is just supposed to kind of mean somehow related to their lot in life as workers. But in this particular case, the facts of this case, the complaints involved, the comments at issue, involved poor customer tipping practices. And the majority held that because the generosity of a customer's tip is not directly controlled by the employer, the discussion of tips is not for mutual aid or protection within the meaning of the Act. The compensation of tipped employees, how it is structured, who pays what, and what, if anything, the employer does to compensate workers for bad tipping, all of this, in my view, clearly falls within the Supreme Court's broad definition of protected concerted activity. I'm actually not sure if any of my colleagues ever worked for tips, but in my experience, having done so, if you asked any tipped employee whether the impact of getting stiffed on tips is a matter of mutual concern to them and their coworkers, I bet I know how they're going to answer. I worry about the implications of the decision, not only because for questions involving like tipped employees particularly, but because of the narrow view that the majority is taking of the concept of mutual aid or protection. It's not only contrary to precedent, as I said in the dissent, but I just think it turns a blind eye to the realities of the workplace and the realities of the lives of often vulnerable workers. So one thing that we've talked about the who, we've talked about the how, and now we're talking about the what. And we've said that they've actually narrowed the definition of protected concerted activity. Correspondingly, on the flip side, the majority has expanded the scope of what is considered to lose the Act's protection. So this is activity that is clearly protected, but that the majority says has gone too far and has lost the Act's protections. Previously, the law had allowed what we call some leeway for impulsive behavior in engaging in activities protected under the Act, particularly when the behavior involved a labor dispute or conduct on a strike or a picket line. Nobody condones this kind of behavior, but it's been recognized that things become heated in the context of labor disputes. But the board and General Motors removed this consideration from the law. Now, workers engaged in protected activity can be disciplined or terminated essentially whenever the conduct violates the employer's decency rules, so long as those rules have been previously consistently enforced and haven't just been enforced for the first time against this activity. A third front in kind of attacking and narrowing protected concerted activity is to exempt from scrutiny broad categories of workplace rules that chill protected activity. The board majority has spilled a lot of ink in the last several years on decisions talking about the permissible scope of workplace rules. Under the new test in a case called Boeing, what the majority has done is to essentially insulate entire classes of workplace rules from individualized scrutiny. And in doing so, they give far less weight to the chilling effect that such rules can have on workers' rights. The Act becomes smaller as a result because the scope of otherwise protected activity that the employer can lawfully restrict or seems to be restricting or can seem to be restricting has grown. What the board has done is to take one particular workplace rule in one particular case and to either determine A, that rule could not be read to apply to protected activity, or where the rule very clearly must be read to apply to protected activity, they've determined that the employer's asserted interest in having the rule outweighs the impact on workers' rights. Then the majority makes a sweeping determination that henceforth all similar rules in all cases will be deemed categorically lawful, regardless of the particular language or circumstances involved. Using this kind of blunt instrument approach, the board has declared categorically lawful all workplace civility rules, rules preventing the disparagement of employers, rules that explicitly prohibit the discussion of workplace issues that are the subject of a pending employer investigation, and rules that require employees to keep confidential arbitration proceedings and results, notwithstanding that these matters are often of mutual concern to all employees. The chilling effect of these types of rules on workers' ability to engage in basic activities protected by the Act, in my view, could not be more obvious. These decisions have a real impact on the day-to-day lives of every worker in America. And this long list of precedents that I've just listed is just involving the area of protected concerted activity. It doesn't even delve into the changes through both adjudication and regulation that narrow the path to getting a union and a first contract for workers that seek to have an organized voice in the workplace. Discouraging voluntary recognition of unions, giving employers rather than workers control over the size and scope of bargaining units, attempting to lengthen the time frame for holding a union election, limiting the extent to which employers can be compelled to come to the bargaining table in a joint employment situation. And even when employees manage to overcome all of these obstacles and achieve union representation, they find themselves in a radically altered legal environment in which the current majority has made it significantly easier for employers to withdraw recognition, even when a union, in fact, may continue to enjoy majority support. Each of these decisions, this kind of death by 1,000 cuts throughout the course of the process, makes the Act less meaningful to workers' lives, and it weakens their voices in these perilous economic times. While there are, as I said, many worker protection laws on the books today, the Act is unique in its flexibility and its responsiveness to changing worker priorities and changing economic circumstances. Workers in the 1930s could not have imagined that the National Labor Relations Act would be invoked by their 2020 counterparts to demand personal protective equipment during a pandemic, to challenge the denial of employment protections in a gig economy, or to protest systemic racism or the silencing of sexual harassment victims. But it is manifestly clear from the plain language of the law that the Act does protect this and more. The narrower, weaker vision of the Act's protections that the majority espouses is both legally incorrect and, I believe, socially and economically detrimental. While the legacy of the Trump board will impact the law for years to come, it will be interesting to see what response this systemic weakening of the law could invoke from other branches of government or from future boards as the kind of tides turn at the board in the future. That's really about all I actually had prepared, but I would welcome the opportunity to chat about other issues or to respond to questions that people might have, and to get recommendations on pizza and bagels.
Mario's in Morristown is my
Okay.
favorite.
That's not too far from Summit.
Yeah, not far. Ricotta and eggplant parmesan. Just, you'll gain 5 pounds just looking at it. So a few thoughts, and as you mentioned, I'm out of Region 5 originally. I was Special Lit and then Region 5 management for quite a few years, and now I'm happily back to being a neutral. And at the board, regardless of what party was in power, we always tried to get it right. We always tried to be a neutral agency, and I'm happy to be back to neutrality. And when we had Chairman Ring last year, I asked him a few questions. So please understand my questions are more to elicit comment. You know, as we all know, when the Dems are in office, smaller units, the cards are good for a year. And I use those as examples. When the Repubs are in office, bigger units and the cards are good for 6 months. That's so a lot of this I look at as being kind of the standard back and forth, and I think that's a positive thing. There were a few cases that caught my attention that went beyond a number of things. Well, for example, you mentioned union insignias at work in Walmart.
Mm-hmm.
It was my recollection that outside of nurses or where the public was being served, employers presumptively could not ban insignias. So that to me is to some extent a return to normalcy, but or what you pointed out is in fact a little beyond what we've seen in the past from both sides. However, you mentioned Felix, which I probably just mispronounced. And My recollection is that for the first time under either Wilma or the Pierce board, for the first time, the board had found that misclassification of employees was an 8A1. So this arguably just seems to return it back to older law. Is my recollection just incorrect?
No, I think that was actually a question that the board had never directly addressed before. VLOX was the first time that they talked about whether misclassification in and of itself is an independent violation of the act. And in some ways, it's kind of a silly and abstract question, because you're rarely going to have a situation where the only charge, the only violation that is alleged is misclassification, as if the worker found out how they were classified. There were no other ramifications of it, and they just wanted to challenge the classification in the abstract. So I think it's kind of an odd issue in the sense that it's almost never going to come up. This is always going to manifest itself in some way. But I did fundamentally disagree with the conclusion that incorrectly informing a worker that they have no rights under the act is simply an expression of opinion and is not a violation of the law. But it was, to my recollection, the first time that the board has explicitly addressed the question.
And certainly it would be foolish for me to argue with a board member, because
People do you should tell that to my colleagues. They do it all the time.
Well, I just don't have the knowledge that I had maybe 10 years.
Yeah, they do it all the time too, actually.
There you go. So yeah,
if I could break in for a second.
Sure.
I just want to ask a couple of questions about a number of things. First of all, thank you, Member McFerran. That was a wonderful recitation of the case law and where we've been and your views on those dissents. I also noticed, I would like to acknowledge Jack Walsh, my colleague in New York, regional director from Region 2, for attending. Thank you and welcome, Jack.
Thank you, Dave.
Nice insignia.
One of the things that we as regional directors, struggled with during the pandemic was mail ballot elections and manual ballot elections. And I also learned at that time that you also have a Twitter account, which I did not know. But on November 9th, after the majority issued the Aspiris decision, you tweeted that mail ballots allow the board to run elections safely and effectively, virtually eliminating the public health risks of manual elections. Mail ballots should be the default approach, at least until the pandemic is over.
Mm-hmm.
So just two questions, because we really struggled as directors with advice. We had a general counsel's memo, but we don't have delegated authority from the general counsel on decisions in representation cases. Our authority in writing our case decision comes from the board. So my question is, we waited a long time for a decision, that gave us some direction. How does the board, in advising directors who act under their discretion, best communicate with directors? Because we got no memos from the board side. It was just looking at decisions. Is that the most efficient way of letting us know what factors should be? And I would just, there's very strong feelings about mail ballot elections. So the second part of that question is, is basically, can you envision during the pandemic where things are rising that a mail ballot election that would not be appropriate?
Those are both very good questions. And for those who aren't familiar, in Aspiris, the majority set out a set of fairly complex and detailed standards that would govern when regional directors should hold mail ballot elections versus in-person elections. And it was one of the instances where people did, I dissent from the current majority for all sorts of different reasons. But this was simply a very good faith disagreement about where we should start from. I applaud my colleagues for the effort that they put into trying to come up with what percentage and whether we should be using countywide or citywide data. And they put a lot of thought into this. I just fundamentally would have came at the question from a different approach, which is the default assumption during the pandemic should be that we do mail ballot elections. Every public health authority, regardless of where, in which jurisdiction, would say that you avoid unnecessary gatherings. When you can use an alternative means to have an election is by definition an unnecessary gathering. And the fact of the matter is that we are not public health authorities. We don't know whether county data or city data is more reasonable, whether 5% or 6% is the appropriate threshold for danger. We don't know, how big a room has to be or how much air circulation it has to have. We're labor lawyers. What we do know is that we can, in the vast majority of cases, hold elections by mail ballot. And my position simply was that it's much easier to start with this assumption that the pandemic is an exceptional circumstance. That means we should start with mail ballots. Your question about, certainly decisions are the primary way that the board historically has given guidance to regional directors on issues such as this. Now, the regional directors are performing a delegated function from the board in holding elections. So, I mean, it has not historically been the case that the board has given guidance to regional directors in some other forum. I have to put some thought into whether and how we could appropriately do so. But certainly, this decision was our effort to do so. It took a little longer than we wanted to get it out, because they always take a little longer than we get it out. And again, because we're not public health authorities. I did also, in that dissent, talk a little bit about the kind of antiquity of the board's norm that in-person elections are always the default and must be the premise from which we proceed. Many of our sister agencies, the FLRA, the National Mediation Board, et cetera, have, with advances in modern technology and changes in the nature of the modern workplace, stepped away from in-person elections being their default norm. And I did, in that decision, speculate that the board should seek input from the public on whether the board should consider that option as well. It may well be that in the 1940s, everybody gathering physically in person in the same workplace was the ideal way to make sure that we were maximizing voter participation. In a world where, I think post-pandemic particularly, an increasing number of workers work remotely a lot of the time, if not all of the time, where the kind of the nature of an individual workplace or an individual bargaining unit can be huge and not local, where technology can be easier and at least less expensive to implement, to do things remotely. I think the board should really give some thought to whether we want to kind of get in the modern era when it comes to how we conduct our elections, but we should certainly do so during the course of this pandemic when we can avoid unnecessary gatherings.
If I could just follow up on that, because you wrote a 100-page dissent to the rules on the elections.
Which set of rules on the elections?
The ones that are halfway.
Blocking charge rules, I'm assuming, not the ones that were done by direct final rule. Which one? Which set are you talking about?
I believe that what really I was getting to, because I know you've written a 100-page dissent, is you spoke to us when we were down in Washington in September of 19. I think the last time all the directors could gather in person with the board, and you spoke, very, very interestingly and very movingly about why dissents are written and in what circumstances you would consider writing a dissent. And particularly, my thought was, if you wrote 100 pages, that you really wanted to write that dissent. What are the factors that you think about, when you decide to dissent on a case? People
write dissents for all sorts of different reasons. I personally write dissents for all sorts of different reasons, and it depends entirely on the facts and context of the case and what I'm trying to achieve. Sometimes I'm trying to clarify the scope of what the majority is doing, or kind of limit the scope of what the majority is doing, where in the dialogue back and forth between the majority and the dissent, I will say, the majority is doing this and that's awful, but to be clear, they're not doing this, that, or the other thing. And that's because while the majority hasn't articulated in their decision, I want to make clear that the scope of the majority decision is cabined, is limited. There are some times when a dissent is writing for the Court of Appeals, is really a straight up, this is contrary to board precedent or circuit court precedent or Supreme Court precedent for this, that, and the other reasons. I am laying this out there for you, Court of Appeals, because I think this decision is legally incorrect. Sometimes you're writing for a future board, particularly in a situation where it's a matter of more of a policy question. you're saying, well, yeah, the majority has chosen to do this one way, and this is why it is better and more consistent with the purposes of the act to do it another way, and lay out a vision for a future board about what the law, what a better interpretation of the law would be. And sometimes it's just like, I call these, sometimes it's just the primal scream. It's just like, this is so very wrong, and I can't wrap my head around how anyone could write this decision this way. And I don't know if I've written one of those in a while. Wilma Liebman wrote some good ones. I remember that. But sometimes it's just like, this can't possibly be right, and it's offensive and it's wrong. I don't write very many of those, but sometimes I have to restrain myself from it. But there's all sorts of reasons. And sometimes there's reasons not to dissent. In fact, these are the best case scenarios, when the board members can all kind of get together and put their heads together and say, well, if you don't go here, then I don't have to go here. And we can decide the case on these very narrow grounds. And it may not be the perfect outcome that I want, but it avoids what I see as a worse outcome. And from their perspective, avoids me breaking them over the coals for doing something they're not really intending to do, or they would maintain that they're not intending to do. So sometimes not dissenting is really the best strategic decision of all.
Let me ask a question, David, unless you're done. I'm sorry.
Go ahead. I'll come back.
Okay. Yeah, we could kind of alternate. I think there's a lot of interesting issues out here and cases. And
we want to make sure that people who are participating today and
Yeah.
attended, if you have a question, please send an email or a chat. And Jim Kinney is watching those, so we can get these questions that you have as well.
Yeah. I'm watching them also. I've sent out a couple of requests. You had mentioned a case, General Motors. And General Motors is near and dear to many of us because Pier 60 is a Region 2 case. And in Pier 60, a individual at Pier 60, which those of you in the city may know, it's a restaurant on the pier, sent out a social media text or tweet or something calling his manager certain choice words, the manager's mother certain choice words, and then vote yes for the union. And the board issued, Karen Fernbach was the director, the board issued, and eventually the board found it was a violation, even though I think the second may not have taken the same view.
No, they did. The Second Circuit affirmed.
Oh, okay.
I was the regional attorney on that case, Dean.
Got it. Got it. Well, then my comment is directed at all you guys, which is, as somebody from Queens, if you talk about my mother, that's a whole different discussion. But putting that aside for a minute, with General Motors said, now we're going to apply right line. At some point, we'll have a Democratic majority. What should be the guidelines there? Because General Motors says, if you're engaged in, if you make severe racist comments, it used as an example, severe sexist comments, and I assume it referenced Pier 60. I haven't read it in a while. What should be the outer limit, or is that something you can discuss and you're able to discuss?
Unfortunately, while I discussed many of the cases in my remarks in more detail, a careful observer would have noted that I only listed the holding of General Motors. Okay. And that is because General Motors was decided while I was away from the board on my little 9-month hiatus, where I discovered that I'm a terrible Zoom school kindergarten teacher. Yeah. But I cannot opine on whether General Motors was correctly decided, or how General Motors might or not should be altered in the future, because that was a case I did not participate in, and those are issues that might come before me as a future board member. So I can list you the holding of General Motors. I can talk a little bit about Pier 60 and exactly the amount of profanity that was completely normal in that workplace, including discussions of many, many people's mothers, I would fathom. But I can't really talk about General Motors in any greater detail than that.
Understood. You did write a decision in, and I want to make sure I pronounce it, Apogee. And Apogee reversed Banner. And Banner is the case that held, that put restrictions on the employer's ability to tell employees to hold an investigation confidential. And I totally get it, because you have Section 7 rights to be able to chat with your employees regarding terms and conditions, and a bad supervisor or an issue certainly is encompassed by that. What about where you do have, for example, an investigation of sexual harassment, which can be pretty delicate? How would you see Apogee and Banner impacting that in your dissent?
Well, as I said in the dissent, it wasn't as if Banner and the rule under Banner didn't allow for consideration of the sensitive nature of an investigation. All that it required an employer to do was to do a particularized inquiry about whether this particular investigation, there was a reason to keep it, to require confidentiality. If they had concern about evidence being fabricated, or about, witness testimony being generated, or things like that, or if there was a determination that the sensitive nature of the particular allegations in this case required confidentiality, the Banner-Estrella test allowed for that. What Apogee does is make a categorical determination that whenever there is the pendency of an investigation, and these investigations can go on for years and years, if you've got a powerful person and nobody really wants to pursue the investigation, we'll just say it's still under investigation, that during the pendency of the investigation, you can put a gag rule on the people who are involved. And while the majority has all sorts of ways that they cabin the impact of their decision here, they say, oh, but it only relates, we don't prevent the rule doesn't prevent them from discussing the events underlying the investigation. It only prevents them from discussing what happened during the actual aspects of the investigation. These are meaningless distinctions to the workers involved. If they are told at the beginning of an investigation that they can't talk about anything involved in it, they're going to think they can't talk about anything involved in it. And that's the kind of thing that silences workers and puts gag rules on workers in inappropriate ways. I feel very strongly about this, as the dissent probably revealed. That's why Me Too problems, for example, can fester in the workplace. When somebody is told that they have to keep their mouth shut and not warn the coworker next to them, or warn the intern that somebody is a predator. Telling people that they can't have their own voice and self-advocate to try to address their workplace problems, but they have to defer everything to the employer's investigative process, is how powerful serial harassers can go on for years without repercussions.
Got it. Thank you. Thank you. That makes a lot of sense. I appreciate the fuller discussion. Lou Verone. Lou asks, has there been any discussion about who the president-elect may nominate for the current vacant seat on the board?
That is way above my pay grade.
I also assume you cannot discuss, as the only Democratic board member, who we could expect to be the new chair of the board.
I certainly would never want to publicly speculate about that.
We've got a really good question from Ellen Oxfeld. Does it make sense? And I assume that this is now that Babcock and Wilcox has been overturned. Does it make sense to encourage a charging party to withdraw a somewhat but distantly related grievance so as not to be due-boat?
I'm sorry, I missed the last part. You might have cut out or something.
Sure. Does it make sense to encourage a charging party to withdraw a somewhat but distantly related grievance so as not to be due-boat?
The Babcock and Wilcox, the decision there, and I'm going to look at one of my staff attorneys who I can see on the phone, came out while I was gone, if I'm correct. Am I correct on that?
It's the postal?
The arbitration deferral decision, is that what we're talking about?
So, right, so United Parcel Service came out while you're on hiatus and UPS overruled Babcock.
Yeah. So that, unfortunately, is another decision that I have not had the opportunity to opine on yet. So I probably should keep my mouth shut for the time being until I have the opportunity to do so.
Got it. Let me ask you a somewhat related question, or at least one that goes to arbitral standards, since a number of us are practiced before neutrals or are neutrals. MV Transportation, the contract coverage case, which I don't think has gotten nearly the attention it should have, which changed and this is an example where I kind of scratched my head because the clear and unmistakable waiver standard has been there since before I practiced law, for decades. But now the board has adopted this contract coverage on 885 unfair labor practice charges, which instead of looking to see if there's a waiver, looks to see if the issue is encompassed within the language of the contract. How is that going to change the way in which the board views 885s and also deferral cases?
Well, what I said in the dissent, I think, is that I'm worried that the primary impact of it is going to be to make it harder to reach agreements. Why would anybody agree to a management's rights clause, basically, if it's going to be interpreted to encompass essentially free power to do anything you want? I think it's going to make it much harder for these agreements to be reached in the first place. So I think that's the most damaging. And I take your point, Dean, that it's one of these kind of mystifying to me situations where the majority took something that wasn't broke and tried to fix it. And everybody kind of knew everybody knew it wasn't like ideal. It was hard to explain to people. I wouldn't have wanted to teach the labor law class where you were talking about the difference about contract coverage versus clear and unmistakable waiver, but kind of people who were in this world knew how it worked, and no court had really ever, the courts hadn't really looked askance at this, is my recollection, that this was just kind of the way it worked. And now we've kind of upended that. And like I said, my biggest concern about this, as I articulated in the dissent, is that it's going to make bargaining harder.
And it'll make bargaining harder because now unions will have to put in every piece of language, because otherwise it'll be considered waiver, essentially.
Yeah.
McFerran, if I could raise the question of rulemaking. This last administration seems to have, the current board has been using rulemaking far more than we've ever seen before. And I know you have tweeted on this, I have one in front of me, about rulemaking and the circumstances and what the issues are with that. Would you care to comment on that here?
Well, actually, yes. I mean, John Ring loves rulemaking. Chairman Ring loves rulemaking more than my 6-year-old loves Star Wars, and my 6-year-old wears Star Wars underwear. So that's like a really big level of affection we're talking about. But I'm not opposed to rulemaking. I should be clear. Like, I'm the child of an administrative law professor. I knew Chevron before I was in high school. Like, I don't disagree with, there's aspects of the notice of comment rulemaking process that I think would greatly benefit from the board. I think many of the board's major adjudications under this chairmanship have suffered from a lack of public input. This board does not like putting things out for public briefings. They do not like putting things out for briefing to the parties sometimes. And I think using rulemaking has some real benefits in terms of allowing and requiring that level of public input and response to it. It just happens to be that I would use rulemaking in completely different situations than the current majority would. Let's take the contrast between the Boeing decision, which was a single adjudication about a single no camera rule that resulted in the creation of an entirely new complex system with multi-steps and categories and prongs and Lord knows what else for the evaluation of workplace rules. This was textbook rulemaking by adjudication. There was no public input. There was no comment sought. There were categories of rules, like civility rules, declared categorically lawful in that case that weren't even at issue in the case. Compare that to the joint employer rulemaking, where we have a proposed rule that takes an issue that is so inherently fact specific. Every employment relationship is completely different. Like the nuances of how these relationships between the companies are structured and who controls what and who's determining what and what's in the contract. And those are so inherently, kind of fact bound that it was really mystifying to me when I was dissenting from the proposed rule as to why you would pick this issue that seems so suited to individual adjudication to do rulemaking, to use rulemaking with. And the thing to remember about rulemaking, it's not a muscle that the agency has flexed a lot. It takes a lot of time and resources. Every every attorney that's being pulled aside to review comments in a pending rulemaking is an attorney that's not writing bench memos and decisions and helping adjudicate cases. But it's not a bad choice to make. I'm saying it's just, you have to be, it's once you make that choice and you flex those muscles and you get the agency ready for that, the question is, do you want that to become the new and default way that the board does business? Do you want this rule to be overturned in the next administration with that rule to be overturned in the next administration with that rule? It may be a little slower, it may be a little more cumbersome, but the same thing can happen once the agencies learn to do it.
Let me ask you this, and I'm going to ask you the same question that I asked Mark several years ago, and I'll admit he kind of yelled at me when I asked the question. I've been around long enough to remember when the hospital rules were enacted, and I was with the board and trying cases under them, under the new rules. But no one really seems to have tried the rules or rulemaking until the election rules. And so it appears as if the Dems came out with that, and it was post-EFCA, and it hadn't been done in decades. And then the Repubs came out with rulemaking for the joint employer piece. So it seems as if that got suddenly resurrected after many years under the, I don't know if it was under Wilma or under Mark Pierce.
It is certainly factually true that that was the first major rulemaking that had happened in a while. That being said, again, in my view, that would be a situation where you look at a topic that is inherently very well suited for rulemaking, i.e. the agency's procedures for doing something. Now, I would quibble with the majority's determination in their last round of election rulemaking that they could do it without notice and comment. I did quibble with that quite a bit.
Yes.
But I think it's just a question of, again, of that. Was that an attempt to open the door to a whole new world of rulemaking at the board, or was that just a determination that that kind of comprehensive reform of the board's election processes would have been completely inappropriate to do in an individual adjudication where certainly not every issue touched in that rulemaking could possibly have been addressed in any individual adjudication, and the kind of the volumes of notice and with two processes, we went through two notice and comment process with that the Obama board's election rulemaking that resulted in public hearings. I mean, the amount of public input that we got was really pretty vital to that process. And in the original rulemaking, the final rule differed in significant ways from the original proposed rule because of that process. So I think that process was absolutely vital, and it was a good topic on which to try to do rulemaking.
And certainly we can look at the statistics, and it looks as if it really didn't have that big of an impact either way. I mean, did it really? I mean, certainly the rules needed cleaning up with the technology. Has it really changed the outcome of elections? It looked as if it was fairly flat.
And I think most of the analysis that I've seen of the Obama board's rule was that it did tighten the time frame for elections relatively significantly without having any substantial impact on the union win rate versus union loss rate, or in either certification or decerts, I believe. I don't have those numbers in front of me. Interestingly, I guess there was it a Bloomberg piece last week or something where Bloomberg did its own analysis of the impact of longer election timetables under new protocols, and partly attributable to the pandemic, though they tried to kind of parse those effects out. And that was, I have no idea whether it's correct or not. I haven't delved into the numbers that they used. They did their own analysis, but they said that those changes have significantly increased the timetable of the election, and I believe said have diminished the union win rate. Though I don't know, like I said, I cannot personally vouch for those statistics one way or the other. It was a Bloomberg analysis done last week or the week before, I believe.
I think, David, in the year-end board numbers, and maybe it's the GC's numbers, the last one I saw, which would have been last year, looked as if the number of days was maybe trimmed by 3 or 4, but the win rate was within the same percentage.
That would for the Obama board rules. That sounds about right.
Yeah.
But like I said, I don't know about the analysis, this Bloomberg analysis of only a few months of time under the kind of the ring boards approach,
Okay.
and how accurate that is. But the conclusion was by the journalist that elections were longer and unions won less.
Okay, we have a question from Nick Lewis. In light of the multiple manners in which you described the Trump board narrowing the scope/purpose of the act in your initial comments, do you see that having an impact on the degree to which workers and labor organizations seek assistance from/engage with the agency?
That's a difficult question to speculate about. I think our charges have gone down in recent times, but there's so many potential factors that could be at play there. I think it is really difficult to speculate about why exactly charges have gone down. These things do tend to run in cycles. Even in the limited time that I've been at the board, everyone's like, oh, charges are down, we should respond to the decrease in charges, and then the next year charges are up. And that's why I think we shouldn't necessarily read too much into these fluctuations in the amount of charges that we're receiving when it comes to, for example, like the robustness of the agency staffing levels and things like that, because they just tend to fluctuate over time.
Sure. Let me, and I'm not sure if you can comment on this, but what is the future of the beloved scabied rat?
I definitely cannot comment on that. Isn't there like an active request for briefing out on that or something like that?
I think there is.
There is.
Member McFerran, I think one of the concerns, I think, of the practitioners, we have both management and union side practitioners before the agency, in this meeting, is that there are vacancies now around the country in the regional director's position, including in Newark. The board has a role in the process, as does the general counsel. Would you care to comment on what the roles that the board members will play on, number one, whether Newark would be continued as an independent region, and two, if it is, who the next director would be?
That is again, non-public agency information that I cannot share. To the extent I'm not confirming or denying that any such discussions are taking place, I simply cannot talk about those kinds of internal agency matters, other than to say that I have publicly expressed before that I am concerned, and I want to see our regional offices fully staffed. I want to see our regional offices have the leadership they need. We have, the last appropriations bill contains some pretty explicit language from our overseers down the road, or up North Capitol there, about their concern about decreased staffing levels at the agency, vacant regional director positions. So I think that any future leaders at the agency, whoever those may be, should certainly take those concerns seriously.
Well, I asked that question because I urge all practitioners at every meeting I attended during my tenure as director, to write to the general counsel and to write to the board. It was always my understanding that after every director retired, that there was an internal review by operations, which is on the general counsel side, but that we always understood that the existence of regions and the parameters of a region were within the board's discretion to decide. So I'm just in terms of who to write letters to say keep Region 22 alive and independent. I was just trying to ascertain is who they should write to.
One thing I would say is, in addition to writing letters to whoever you might choose to write letters to, your congressman or your representative or whoever, the general counsel or whoever, people should apply for these jobs. If you are an experienced labor law practitioner and you have thoughts about how a region should run, apply for these jobs. We want to see reams and reams of resumes from experienced labor law practitioners in reviewing applications for these positions. And sometimes we don't see that. And so if you have a thought about how a region should be run, apply to be the regional director, apply to work for the region, apply to work in a regional office. We want you, as they say, we want your talent. We want your background and your experience at the agency here. It won't be the most money you've ever made, but if it's a law you love, you should jump in and work with us.
Let me, on a related question, first I point out that the Jersey Labor and Employment Executive Committee sent a pretty strongly worded letter to our representatives and to the GC, which David, I believe, was raised by the GC, specifically in a discussion to you, which is always good to hear. The other thing is that during my career, I've had, for example, ALJs who clearly did not come out of the board. And it got a little scary when you're explaining to an ALJ 8A3 of the Act. And it's my understanding that at least one regional director recently appointed did not have a board background, which was kind of astounding. And I don't know if that's correct or incorrect. Do you see that happening again?
I don't want to comment on particular hiring decisions. Like I said, I would just say that the board is always looking for talented labor law practitioners, and in a variety of roles and in a variety of ways. And it's a wonderful place to work. It is a fabulous job where you get to think about interesting things and work with wonderful people. Really, I mean, I've worked with senators, I've worked with representatives, I've worked with Hill staffers, I've worked with practitioners. I have never, been more impressed than by the people who are virtually now within the walls of this building. It's a great team, and if you're concerned about the quality of the people you're interacting with, join our team.
Excellent. That was a great recruiting pitch.
Yes, I think it's great.
I have to tell you, as a young lawyer starting out with the NLRB, I could not have been happier.
Yeah.
And it's just been a wonderful thing for my career.
You will learn a lot.
Yes, you learn how to write and how to think. It's just a great place to be.
Mr. King, do we have any more questions?
Yeah, I don't see any.
No?
No, not this time.
Should we pass this over to Lucille?
Yeah.
To call us to a conclusion?
Well, first, let's give Lauren a big round of applause for a one-woman show. She really did it. Lauren, wonderful. Thank you for coming and
Thank you
being
for having me.
guest today. And of course, David and Jean, can co-host. They can do their own show on television. They're really practicing for that. Thank you very, very much. We just want to remind everybody that we are remaining virtual. We're not, as Lauren has said, we have to stay like this for quite a while. So our March program will be reconsidered because, things keep happening. We just can't seem to get back to just kind of having dinner and hugging and kissing each other hello. So we figured maybe we need to address some things that everybody is all in a quandary about. So we are going to be looking at that. We want everyone to stay on top of things, and we want to be on top of that with you. So you'll be getting some emails from us. Our members will be looking at the upcoming elections that Jim Kinney runs, and we'll be giving you a new agenda for March. So do we have a new message, Dean?
No, I just sent a message saying thank you, and I see a few others have come in.
Oh, great presentation. Thank you, Pete. And we do want to say thank you to everybody, and stay safe, please stay healthy, and we'll look forward to seeing everybody in March.